On December 2, 2001, Enron's stock collapsed from a soaring $90 per share to under $1 in a single day, wiping out the retirement savings of thousands of loyal employees and turning a corporate titan into a symbol of American greed. It was a moment that would ignite a legal firestorm and cement one of the most infamous corporate frauds in history. In the late 1990s, Enron was hailed as the darling of Wall Street, a Houston-based energy conglomerate that claimed to have reinvented the way power was bought, sold, and traded. At its helm were two charismatic leaders: Kenneth, the visionary founder who built Enron from a modest natural gas pipeline company into a multi-billion-dollar empire, and Jeffrey Skilling, the brilliant but ruthless former consultant whose aggressive rank-and-yank management style turned ambition into a relentless pursuit of profit. Together, they cultivated a culture that glorified risk, rewarded deception, and silenced dissent. The secret behind Enron's meteoric rise lay in a labyrinth of off-balance sheet entities, complex derivatives, and accounting tricks orchestrated by Chief Financial Officer Andrew Fastow. By funneling debt into hidden partnerships and inflating revenue through mark-to-market accounting, Enron reported profits that never existed. Employees were encouraged to invest heavily in company stock through 401(k) plans, convinced that Enron's growth was unstoppable. When the house of cards began to wobble in mid-2001, the same executives who had promised endless prosperity ordered the company to sell its own shares, while secretly offloading toxic assets and masking billions in losses. The unraveling began in October 2001, when analyst Bethany McLean of Fortune published the now famous headline, "Is Enron Overpriced?" The article sparked a cascade of investigations by journalists, regulators, and a disillusioned board of directors. By November, Enron filed for Chapter 11 bankruptcy, the largest corporate collapse in U.S. history at that time. In the fallout, more than 4,000 employees lost their jobs, and an estimated $2 billion of retirement savings vanished into the void. The legal battle that followed was as complex as Enron's financial engineering. In early 2004, a federal grand jury in Houston indicted Skilling, and Fastow on 11 counts of fraud, conspiracy, and insider trading. The prosecution, led by Assistant U.S. Attorney John H. Tisdale, painted a picture of deliberate deception. And Skilling allegedly knew that the company's financial statements were false, while Fastow's shadowy partnerships were used to siphon money into the pockets of insiders and to hide mounting liabilities. The trial began on January 30, 2006, in the United States District Court for the Southern District of Texas. The courtroom was packed with former Enron employees, investors, and a nation hungry for accountability. Prosecutors presented a mountain of evidence: internal emails boasting about making money for the shareholders, presentations that glorified creative accounting, and testimony from whistleblowers who described a culture where dissent was punished with termination or demotion. One former Enron trader recounted how he was instructed to cook the books to meet unrealistic earnings targets, while a former HR director testified that the company's retirement plan was deliberately marketed as a safe harbor for employee savings, even as the leadership knew the stock was a house of cards. Defense attorney John L. Jack G. Brown tried to argue that and Skilling were merely ambitious businessmen who had been misled by a rogue CFO. He painted Fastow as the mastermind, insisting that the top executives were unaware of the intricate web of special-purpose entities that concealed debt. Yet the jury heard Lay's own words from a 2000 conference call: "We're not just a company, we're a family, and families look after each other." The contradiction between that sentiment and the reality of mass layoffs, stock price manipulation, and fraudulent accounting was stark. After 6 weeks of testimony, closing arguments, and deliberations, the jury returned its verdict on May 25, 2006. Jeffrey Skilling was found guilty on 19 counts, including conspiracy, securities fraud, and insider trading. Kenneth Lay was convicted on 6 counts of fraud and conspiracy, though a mistrial on the remaining charges left a cloud of uncertainty. The conviction sent shockwaves through the corporate world, confirming that the highest echelons of power could be held accountable. Sentencing followed later that year. Skilling received a 24-year prison term, later reduced to 14 years after a series of appeals and a controversial agreement with federal prosecutors that granted him a modest reduction in exchange for his cooperation. Lay's sentencing was delayed by his battle with terminal cancer. He died on July 5, 2006, before he could be formally sentenced, his death sparking debates over whether a posthumous conviction could ever truly deliver justice. The aftermath of the Enron scandal reshaped the regulatory landscape. In 2002, Congress passed the Sarbanes-Oxley Act, imposing stricter auditing standards, greater corporate transparency, and criminal penalties for executives who knowingly misrepresent financial information. The Securities and Exchange Commission tightened its oversight of public companies, and the public became far more skeptical of corporate hype. For former Enron employees, the damage lingered. Many never recovered their lost retirement funds, and a generation of accountants, lawyers, and financiers carried the scar of having witnessed one of the most brazen betrayals of fiduciary duty in modern history. Enron's story remains a cautionary tale about unchecked ambition, the perils of a culture that rewards short-term profit over ethical conduct, and the devastating human cost when leaders betray the very people who help build their empire. Subscribe to The Verdict for more stories like this.